Record. Awesome, man. So when I mean everyone is dealing with this every day, man, you got individuals who end up in situations where an item goes into collection or it goes to charge off, and they got these debt collectors harassing them. It's harassment. Now, first things first, if you ever receive one of these letters, pre-litigation letter, or let's say it's a letter that is demanding that you show up to court on a certain date, and it'll have like very subtle words. It's not going to be very direct. It's very wishy-washy. So what's going to end up happening is you're in this predicament where you're reading a letter and you think that you are required to go show up to court, right? To represent yourself or present yourself on behalf of this case, because what they're doing is they're suing you. They're attempting to sue you, and they're going to end up winning if you don't take action on your end. And what I mean by winning is what ends up happening in these situations, guys, is people don't know what to do when they receive these letters, because you can actually counter sue them if they sent you a bogus letter like this. It's harassment. It's against the FDCPA laws because they first have to validate the debt. Mind you, if they send you a letter like this, you know, everyone is already aware of the fact that there's the validation of debt letter, but not a lot of people understand the procedure on how to move forward with these actual notices. So let's pretend a client, and this is something you can also, eventually, as you get more educated with this, upsell in your services, right? To assist individuals with how to navigate through this. Because this is so common, guys. People are going through credit repair, and while you're repairing their credit, or while credit repair is taking place, they're receiving all of these letters because now all of these creditors are selling the debts or have sold the debts. They've seen that you're disputing it and that you're taking action to have it removed off your file, right? And it's not in their best interest for that stuff to be off your credit, because that means you'll have good credit, you'll have more access to more capital. And they don't want that, right? They want you to have a low credit score and have high interest rates because everyone else wins in corporate America when your credit score is low, right? Your mortgage interest rates are high, your auto loan interest rates are high, everything is high. Everyone in the back end makes money when your credit is low. So it's not in their best interest to help you in this particular situation. So I'm going to go through this as if I received this letter, right? Like I'm pretending I received this letter, right? To give you guys a different perspective of how I would view this, okay? So the first thing I would do is no matter what situation you're in, right? You have to, one, be in the right mindset. Two, you can't let things get to you, man. You have to realize that we're living in the matrix and nothing's real, right? And what you think you will manifest. So if you're thinking negatively about situations, it'll manifest. You thinking positively about situations, it'll manifest. So first things first, I'm just gonna simply go through and I start reading everything line by line, right? I look to see all of the actual details that are in this specific document. So a lot of people make the mistake of reading a few lines and then their heart starts beating because they're like, damn, I'm getting sued. And they put the letter down, right? That's typically what's happening, right? Because people just don't know what to do. So you start reading all the details, right? So we've noticed that this is a pre-legal notification. So pay attention to those words. It's a pre-legal notification. Okay. Now, regarding this balance that was due to Midland Credit Management. So it's stating that it's due to this credit collecting company. The original account was Amazon. So it's giving you your account number and then the date that this was delivered. Okay. So one thing to pay attention to here too is they're claiming that it's due to Midland, right? But the original account was Amazon. So how did this end up happening, right? Well, first things first, when you are dealing with these companies, right? Let's pretend I have an Amazon credit card. I would go to the CFPB and I would search up the credit card agreement for Amazon. And the reason I'm doing this is because I want to show you guys exercises, just going back to the basics. Remember, the only reason you received this letter is because you went into an agreement. So how do you determine whether things are happening accordingly? Go back to the agreement. It's basics, right? So I'm going to search up the Amazon. See if I can even find Amazon on here. Let's see. Amazon. Right. So I got the Amazon credit card agreement, consumer credit card disclosure. All right. So typically, it's not mentioning it. Now, this may not be the exact one that we're dealing with this particular case, but I just want to show you what I would do, right? I would go back to the agreement in this exact example I'm sharing with you, right? And this is why I want you guys to have a general knowledge and not follow everything I do tick for tack, right? Because that means you're not understanding, you're just copying and pasting, right? So what we're doing is we're going back to the original agreement. So I'm looking for an original agreement, one that I can actually give you an example of. So here's the Amazon Visa credit card. Here it is. So it's a Chase card. So this is a Chase agreement because Amazon is partnered with Chase, right? So because that's the case, what we're going to end up doing here is we're basically going to review its disclosures around transferring the accounts, right? Because it's going to disclose it. It's going to disclose it. Transfer or sell. Let's see if I can find it for you guys. All right, so the relationship. So as I zoom in here, so it's actually giving you everything. Okay. So communication, we may send cards, statements, and other communication to any mailing or email address on our record. If more than one person is responsible for this account, then we can provide a billing statement communication to one of you. All right. So fourth, let's look for it here. It says, we may obtain and review your credit history, credit report agencies, and others. We may, from time to time, obtain employment and income data from third parties to assist us in ongoing administration of your account. So they're telling you what they're doing here, guys. When we're dealing with credit repair, they're telling you that they're physically going to be leveraging third parties. This is why we opt out. So we may also provide information about you to your credit reporting agencies, and we may provide information to credit report agencies about this account in the name of unauthorized user. If this, if you think this, if you think we provide incorrect information, please write us and we'll investigate. All right. So in this particular case, it's telling you this agreement or your account will be governed by federal law as well as law of Delaware and will apply no matter where you live or use this account. So you have an Amazon account, bro, right? You have an Amazon account. When you're going to court, if they're not suing you in the state of Delaware, they can't enforce it. Point blank. That's the original agreement. You understand? So this is already a revealing point and a revealing flaw here. Look at this here, guys. What does this say? If I had an Amazon account and the account was transferred to Midland, Midland still has to follow that agreement. You see what I'm saying? Midland still has to follow this agreement, guys. So if they let's say already filed a lawsuit, they have to actually file it in Delaware. So if they file it in your state, you easily get that dismissed. It's out of the window. It's done. That's your angle. You're going to use that angle, right? Because it's technically a breach of the agreement, right? There is an assignment. We may assign your account, balances you owe, or any of our rights and obligations under this agreement. This third party is then entitled to any of our rights that we assign to them. Guys, I want you to read this. It's telling you everything. I'm not making none of this up, right? I'm not a genius here, guys. I'm just not. I'm just going right back to the source, right? Because how do we end up in this mess? We signed an agreement. We just have to go back and read that same agreement to see what verbiage they use in the agreement and then leverage it against them if they do anything otherwise, right? So in this particular case, we've understood two things, right? We've understood that if this ends up becoming a full-blown lawsuit, okay, they do fully go through and file a complaint with the court, it has to be in accordance to the laws of Delaware. And it will apply no matter where you live or use this account. It says it right there. So now that you're aware of this, right? And this is an exception for New Jersey residents. All provisions in this agreement are valid, enforceable, and applicable in New Jersey, right? And then there's some Military Lending Act notices, but that's what I wanted to share with you. Now, the next thing we're going to do too is look to see if there are any arbitration clause. Okay, so there is no arbitration in this particular case, right? There's no arbitration. So we've noticed, well, I'm like super versed on these statements now, guys. It's like second nature. But I wanted to share with you guys specifically what I would do. I would literally go and read the agreement because Amazon is partnered with Chase. And so when you apply for Amazon card, you are getting it through Chase Bank. Okay? One of the biggest companies in America working with the biggest bank in the world. Chase is massive. Chase funds the world, basically. So, that being said, now we've determined a couple of key points that we're going to leverage as we continue to read this. So now that we determined that it's an Amazon account, we have the agreement. At some point, it was transferred to Midland. So now what we need is to determine whether a bill of sale had taken place. Because if it was transferred, there has to be some paperwork in between it. So we need to reach out to Amazon and say, hey, Amazon, it's my understanding that you had transferred this debt based on the agreement to Midland Management. Can you provide me with the bill of sale? And they're supposed to provide that to you. And once they provide you with that bill of sale is going to have very specific information on it. And what you're looking for is any flaws, right? Because I've helped individuals in the past, and what we've learned was when we look at some of these accounts, sometimes it's missing the account number and the actual client's and representative's name. It doesn't even have the client's name. So how can this bill of sale be transferred? It has no proof of who the individual is, and it also has no proof of the account number. There's no trace of this actually being proof that it is his debt. So therefore, we were able to get that case dismissed just off the basis of the bill of sale. The bill of sale helped get that case dismissed because there wasn't enough evidence to prove that he owed on that account. from that bill of sale. And so that credit collecting company or debt collecting company wasn't able to collect. So now, as a result of your failure to arrange for repayment of this outstanding balance, we plan on engaging an attorney. Guys, read this. So we plan on engaging an attorney to review this account. Now, if this attorney finds that there is cause, we will ask that they file a suit in the state of New York. Boom. You got ammo right there. Let them do it. But what I would do is I would start building a case, and I would simply send them a letter. I would send them a debt validation letter, because you want to also build up notices on them. You send them 3 notices. You send them a debt validation letter, right? Debt validation letter. And then once you send a debt validation letter, you wait that 30 days. If they don't respond, then you give them a second and then a final notice. It's the administrative process. They have to follow through. And that's that, right? It's the administrative process. And that's how that works, guys, right? So in this particular case, it's stating that it's going to file in the state of New York. But when they file in the state of New York, we have to determine if it's aligned with the laws of the state of Delaware, because that's what the agreement states, okay? So back to what I was saying here. We plan on engaging an attorney. So they haven't even gone forward with anything. No one's filed any court complaints. You haven't even been sued. Like, the complaint hasn't been filed, right? But then they're telling you that they're going to file it. And if they file it, they're going to do it in the wrong state. Because remember, all of it is in accordance with the state of Delaware, in accordance to the agreement, or it's a breach. Now, because your account is originally with Synchrony Bank and the underlying promissory obligation was sold to Midland Management Incorporated, we are legally required to inform you of certain rights. This notice satisfies as legal requirement. You have 30 days of this date in this letter. See for your reference for additional details, right? Now, it's important to note that although your account was charged off by Synchrony Bank, the outstanding balance remains valid due and owing. Filing a lawsuit can be expensive, time-consuming. You want to avoid expensive and hassle, and the expense and the hassle as much as you do, please call us. So this is all just a scare tactic, right? It's all just a little scare tactic. Now let's read the bottom here, right? For your reference, the account number, right? You got the account number, the account name is charged off, and then the charge off balance. You may request the following information by writing us here, right? So what I would do is I would actually send the letter for debt validation here. And the same will be provided to you at no cost within 30 days of receipt. An account statement and a complete transaction history is applicable, reflecting the name, last 4 digits, blah, 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 right? They're telling you where to send them the debt validation letter. So when you're crafting that letter, you got to send it to this address that's on the bottom here. So they're instructing you, right? And that's how it works. As an explanation of how many we are seeking to collect in excess of the charge-off, and we calculated, if applicable, the terms and condition applicable to this account. Right? So this is why if you don't understand the terms and condition of this account, you're not going to know how to move. You won't know how to pivot. You're not going to know how to pivot, right? Because if you don't know how to pivot, you're going to be pretty much stuck. You're going to end up making the wrong move. They're going to end up winning. And usually what happens when they win some type of lawsuit, you're not going to end up going to jail. Nothing crazy is going to happen, right? what they do is they end up winning what's called a default judgment against you, or some creditors end up like, or debt collectors end up winning garnishment, right? And they enforce garnishment on wages. While all of that can all be reversed, a judgment and garnishment can be reversed. That's what ends up happening, right? They just get a default win. If you don't show up, if you decide you're just gonna be like, whatever, I'm gonna ignore them, that's what's gonna happen. It's happened to me in the past, right? I've had that happen to me. Nothing happens, guys. Like, the world doesn't end. But it's important that you do something when you get these letters, because you're going to have the ammo to handle this. I'm giving you guys all the game. And what I'm teaching you here is at the end of the day, when you read your agreement and you understand what you got yourself into, it's easier to actually know how to find a solution. But if you have no clue what says in the agreement and you're looking for guidance, you're still going to be clueless. You'll never know really what you got yourself into. And that's one thing I always tell people who are looking to discharge mortgages, discharge auto loans. Like, if you don't know what your agreement says, you don't have the power, because you don't have the knowledge and the agreement to leverage it, because you have to use it at your best ability, and you also use it to work against these companies because they set themselves up, guys. I want you to remember that. And I tell you this all the time, especially when we're dealing with bill remittance and negotiable instruments. A lot of individuals give up in the enforcement. What they don't realize is the enforcement is in the agreement. So if you follow what says in the agreement, you're still paying on time, you're leveraging the negotiable instrument, and you're sending it to the instructions that it states, and they don't accept it, they breach the agreement. You can sue them. You're going to win. But people don't want to go that far. Everything is in the agreement. The answers are in the agreement. Right? And so when this question was dropped in the chat, right, I was like, all right, well, let me give a breakdown. But I'm like, this is going to be a better opportunity for me to start sharing with you guys what's in the litigation campus. This is part of it, right? When we're dealing with debt collectors, this is so common, guys. People receive these letters regularly. I get clients sending it through email, and our support teams reading all these debt collecting emails. I just got sued. And it's going to get to the point where you guys are going to be familiar with it. Like, you'll know once they've been sued, they were already issued a notice, because they have to send you a notice. They can't just sue you without the notice. Otherwise, you can countersue them. Second, if you were to receive a letter like this, right? If a letter came in like this and the letter states that you have been sued, but then you go on to Pacer, or you go to your local clerk's county court to determine if the court case is legitimate, because that's what you have to do. You go and determine if the court case is legitimate, and you realize that it's not, you can sue them. Because that happens, guys. Sometimes they file false lawsuits on you. You'll get a bogus lawsuit. And I've shared this too as well. I'm actually working on still moving it, but it's this example here, right? I've done it before. We were able to get a dismissal for improper service, right? Improper service was delivered to the location incorrectly according to the regulations of the county, because it's all county-based, guys. So even though you're in the state of, let's say, Washington, one county requires that you're sued a very specific way versus another county. For example, let's say I'm in County A and I'm receiving a lawsuit. They're going to ask me to deliver it, or they're going to ask the sheriff to deliver it via mail or via hand in one county, where the other county, they just want you to send it certified mail and leave it at the last known address. It varies. And I actually break all that down, right? There's service to the wrong address, right? Service by mail without proper acknowledgement, service to the wrong person, right? Some counties, you can't even hand it over to an individual that lives in the unit. It has to be the actual person that is receiving it. So they have to come back and deliver it to that person. But you have to determine that based on the state that you're in, right? And the best way to do that is go into the state channels, because it's going to have the most up-to-date information. You don't want to be Googling that stuff. Just go to the state channels and all the info regarding court cases for your particular state, and it will share that. This is another small claims complaint. This is a little bit different, where I want to just read you a small portion of it to show you when you receive a BS lawsuit, right? Because a lot of these are BS, right? Like, read this part here. So this company suing you told the court that you owe them money. They're asking the court to force you to pay them. They haven't proven it yet. Maybe you owe this money. Maybe you don't. Maybe you owe something, but not what they're asking for. Maybe you owe someone, but you're not sure if this company is the company you owe. It's a joke. I read that. I was like, all right, this is a joke. Let me keep reading. So I kept reading. And this is where they get you guys. You guys need to pay attention, and you got to read your documents. I can't emphasize this enough. You got to read. This case here states that Capital One is the plaintiff, okay? It's stating that Capital One is the plaintiff in the state of Massachusetts. But when you actually read this case, right? It's a small claims case. When you read it, it says Capital One is the plaintiff and they're going against the client, right? This is the attorney that was representing. And I want you to pay attention to this. You read the details here. It's stating that, the defendants established a credit account with the plaintiff, which is the successor by merger to Capital One. The defendants used the credit card account identified by account number and agreed to make payments for goods and services charged and/or cash advances made upon such credit account. Defendants failed to make the payment due pursuant to the agreement in the balance of $6,000, right? And it was charged off in the plaintiff on this date. The last payment was made by the defendants towards the account on this date, and the amount was $890. So as you scroll down, as you're reading it, so plaintiff seeks statutory interest pursuant to this law, and the plaintiff's attorney off record certifies compliance with the Rule 5 of SJC Rule 118. And now this is the communication from a debt collector, R&R file number. Okay, you're probably wondering, what is that? So we pulled an old letter he received prior to this. This was the original notice. So everyone that receives this, whether it's you or client or an individual you're helping with their credit, as soon as they receive this, they need to respond with a debt validation letter within 30 days. Like, you can't waste time, because they're just going to default win against you, even though they're in the wrong. And you all know this. You know they're in the wrong, but they're just going to default. They're going to get a default judgment against you and win if you don't respond. But if you respond and you hit them with the right ammo and the validation of debt and everything that they're required to provide in their request, they must cease and desist. And by cease and desist, they can't report anything on your credit. They can no longer communicate to you until all is provided. The moment they breach that, it's easy lawsuit. You just keep giving them notices and then go back to the court, file a lawsuit complaint. They will settle with you. You're going to get paid. End of story. But what you notice here in this particular case here is this reference number here. This reference number is 1596191. And Rubin and Rothman LLC, right? But when you look at the lawsuit, it's the same thing, but they're pretending to be Capital One. They're not Capital One. Capital One is not suing. It is a debt collector. But a lot of people don't slow down and read everything that's on here, and so it just goes over their head, right? And at that point, it's usually too late, because you didn't actually learn the information you needed to actually reverse this whole issue. And the issue here is that they're harassing you. They're harassing you. They must validate the debt. right? So if you're ever sued by a debt collector, this is the step-by-step in the litigation campus, right? I haven't actually made this live yet. It's an exclusive call because one of the students had a question. I wanted to dive into it. So it's a step-by-step guide of what to do if you are being sued by a debt collector. So I've gone over one scenario because there's many different situations, right? There's many different situations, and you always want to determine if the court case is legitimate, if it's a true lawsuit. Second, you want to read the letter. Read the letter, guys. It's telling you. You'll notice in the verbiage whether you have already been sued or you haven't been sued. It'll tell you. Determine whether they want you to send communication to specific locations. So if I had ignored that bottom section and sent the letter to the same address I send disputes to, I would have already missed the ball there. I've already set myself up for failure because I didn't follow the instructions. Right? So you want to confirm that it's real. You want to make sure the court case is legit, the court name on the document. Right? In this particular case, it hasn't gone to a court. So we don't need to do that. The next step is, was the service done properly? Right? And I was sharing this with you guys a little bit earlier. And what I mean, it's different from county to county, and it's different from state to state. You have to determine that based on where it's been received. Now, if you're not able to file a motion to dismiss, right, you want to determine whether it was improper service. This is an easy way to just get it dismissed without going through the agreement or anything like that. This is just like an easy way to deflect this whole situation. And remember, lawyers do this. This is what lawyers do, guys. They find these little loopholes in the cases where they can just get around filing motions and prolonging the court case. That's why court takes so long, because there's all these little loopholes. And when you understand them and how to leverage them, it's much easier and more efficient for you. So now what you guys are going to like is I've actually taken the time to build individual letters for improper service, right? I have a proper service for everything, improper service. Let me wait for this to load connection. So improper service without proper acknowledgement, right? Wrong address, literally everything, guys. Service by an authorized person. Notice how I got everything lined up for you guys, man. It's good to go, right? And this can all still be done the same way I teach you guys how to submit disputes via the CFPB. Now, I do recommend as you start filing things like lawsuits, you want to start getting more personal with the letters, right? Handwritten signature, notaries, making more official documents. But when you're submitting an initial validation of debt, no need to make it fancy. No need to go get it notarized, send a certified mail. You can send that right through the CFPB, right? Because they're still going to receive it no matter what. And it's a notice. So they can't complain that they didn't receive it. It's recorded through the CFPB. So now all these letters are available to you guys. So it's determining whether it was filed improperly. Okay. And so it goes all the way up to the papers being served too late, right? If they needed to be served by a specific time frame, you could leverage that. If there was no notice beforehand and it was required to have one, you can use that. Served by email or electronic without your consent. Not following local court rules, right? So these are all options, but determining which ones are the best routes for you are going to end up being a situation by situation case. And I would walk you through that, but this is, again, very case by case. And there's too many states and too many counties to be diving deep into this section. This is mainly the guidance that I want to provide you guys so you have the tools to start without having to hire lawyers. You guys don't need a lawyer. You don't need to drop money on anyone to learn how to go to court and win cases and handle this all on your own for literally no money, right? You end up getting paid in the back end if you do it right. Respond before the deadline, right? Of course, it's telling you you have 30 days. And that's why I tell you guys, once you receive those letters, better get to moving you know, because you guys will have access to the letters here, there's no stress, right? You can offer those as a service to your clients. If you have a client who, who receives this letters, you could sell them the letter. This is your university, guys. Like, you're here to become financially free, and you have to leverage what you have. This is all ammo for you guys to be successful and have all the right tools you need. So if you have that opportunity where you have individuals who need that, you don't necessarily have to do it for them. You just say, hey, we provide the letter. We can have it built and ready for you, but you have to mail it yourself and handle all of that from there, right? And that's the most you can do. You don't necessarily have to go all the way with that, right? But it's an option. But it happens a lot, more than you think. It's just some people don't know what to do in that case. Step 4, know who's suing you, right? If it's a debt collector or original company. In this case, it's the debt collector, Midland, right? And Midland isn't actually suing yet. They sent a pre-litigation or pre-lawsuit letter where if you get ahead of it and send that debt validation and then you get ahead of the notices, you're ahead of the ball game. You're going to end up reversing it on them. Reverse uno. Flip the reverse uno on them. Right? So you didn't do business with the collector, obviously, right? And that's why you need the debt validation letter. And you may not have real proof. They may not, they often buy documents, not actual debts. And so that's why I tell you guys, request the bill of exchange. Not bill of exchange, the bill of sale, right? Request the bill of sale, because the bill of sale is what they use to transfer all the paperwork. That's how they get it from one company to the other company. They took the agreement and they leveraged the bill of sale to move it from one to the other in accordance to the agreement that you gave them permission to sell it and transfer it. So they did it. They didn't breach the agreement, right? You just didn't sign an agreement with the new company, right? Which was Midland. You never went into the agreement with them. So the old agreement still stands no matter what. And you have to use it against them. Right? Just because they bought the portfolio doesn't mean that they can prove you owe them anything, guys. And this is important. So I tell people it's an obliged debt. You're not obligated to pay it. You pay it if you want. That's on you. It's a decision you want to make. Right? I'm never going to tell anyone not to pay a debt. I just don't encourage paying debt collectors until they validate the debt. They must validate it first. So, I mean, in this case, you can get legal help, right? And I don't necessarily think you need it if you truly understand what's going on. You're not going to need it. Because as long as you sent your notices and you have all your paperwork, all the court cares about is the paperwork. And you show up with your defense, and you're going to state that you've requested X, Y, Z. It was never provided. Therefore, you demand the case is dismissed for failure to provide proof or validation of debt. And the debt was truly yours. But it requires those notices. Right? And so when it comes to filing it at the court, guys, you want to go to your local clerk's county court, right? And you want to file it there. Right? You want to go and file it there. Send a copy to the plaintiff, the one that is suing you, and keep proof of both steps. Now, what I mean by this is you already, at this point, like, let's pretend we're still in the situation with the example in the university where you haven't been sued yet. You're still in the debt validation stage. But if you've really been sued, what they're going to do, guys, is they're going to send you a letter accusing you of XYZ. So they're going to accuse you and they're going to have allegations against you. And these allegations are what you're going to deny when you're filing your response. These allegations are going to be things such as, defendant failed to, pay full amounts owed on this account. Deny all those allegations. Everything, you're going to deny everything, because the first court case, guys, is you're going in there to deny. Nothing really happens in the first one. When you show up, right, and this is why it's important to respond, because it's not like you're going to this major court case and it's going to be super intimidating. No, you're going to show up in there. You're either going to agree or you're going to deny. You're going to deny to all allegations, and you never want to agree. You deny to all of them. But you want to respond to them and deny all the allegations, because if you don't, remember what I taught you guys. Our courts are based off of assumption and presumption. If you don't deny, they're going to assume that you didn't deny. And that's done for you at that point. Our courts are based off assumptions and presumptions. It's backwards. This is why everything has to be based off facts, and you have to rebut everything. If they claim something, rebut it instantly. Same way they claim you owe this debt, and Midland is like, yep, you owe us this much money. Okay, show us proof. If you don't respond with show us proof, it's assumed that you owe it. That's it, regardless of whether you do or not. So it's important that you respond. Save everything. Keep all the copies of everything that you receive, guys, because you're going to be using that in your case, right? But that is a very short summary of how to handle that part, right? So what I'm going to do is I'm going to go into the next part, right? The first hearing, okay? How to handle the first hearing. So in the first hearing, you're going to expect is what to expect and how to respond, right? It's not a trial. Usually it's called case management conference, initial appearance, pre-trial hearing, or hearing trial, depending on the jurisdiction. And the goal here is to confirm both parties are aware of the case, to see if the defendant admits or denies a claim, like I was telling you before. Allow the courts to set deadlines, right? Discovery, trial, motions. And your motions are going to come in handy when you guys are leveraging the motions to dismiss the case due to things such as improper service or failure to validate the debt. This is where the next trial is going to happen, where you're going to allow the court to set a time frame for you to be able to continue to plead your argument, right? Because you're going to show up and be like, nope, not it. I'm denying everything. Determine whether the case might settle, right? And that's, in that case, depending on the amount of ammo you have on them and how many notices you sent and the corner you backed them into, they may just decide to settle right there. They may not even want to go further because they know they'll lose. So this is why it's important to back them into that corner. Send those notices. Don't waste time. As soon as you get that letter, I'd be firing them off. I'd wait for a response. If I didn't get it within that time frame, I'm firing off the next one. Overnight. They're getting it overnight. I'm not even waiting 7 to 10 days for it to arrive standard. I'm overnighting it. Right? They're going to get all the smoke. You might do. So what you must do is agree or disagree, right? Again, you don't want to ever admit, never agree that you owe a debt and that the plaintiff owes it. Even if you recognize the account, right? If you recognize the account, if you admit it, you waive your defense and they can move straight forward to a judgment. And that's all based on assumption and presumption. And that's why it's so bogus, and it's important for you to understand all of this stuff. All right, so say clearly, I disagree. That's it. And the judge is probably going to ask you, so do you owe this debt? So, Your Honor, I don't agree. I dispute the validity, the ownership of the alleged account. All right, so this keeps the case alive and gives you time to file motions, lack of stand-in, demand proof from the plaintiff that owes debt, potentially engage in discoveries or compel evidence, giving you that opportunity to build up more of your ammo, which you already have. And I'm showing you guys how to build that ammo, right? We started by diving into the actual agreement, right? We went into the agreement, and let's say they do file a lawsuit and they go against the agreement, and we determine that it's against the laws of Delaware because it states that the agreement is based on the federal laws and the laws of Delaware. So if they file it not in accordance to it, you can dismiss it. There are so many angles you could take. I'm just going to give you as many as possible, but you have to determine which one's best fit for your situation, because some individuals are going to run into situations where they can get it dismissed because it was delivered improperly, while others, it was delivered properly. They did go through the proper motions to send the notices, but they just didn't have the substantial evidence to prove that the alleged debt was yours. And that's where you can file motions to compel evidence, right? So by disagreeing, you are invoking your right to challenge the creditor's legal standing to sue you. So the creditor who no longer owns the debt due to securitization or transfer of the trust does not have standing under Rule 17 of the Federal Rules of Civil Procedure or state equivalents. They must prove assignment, chain of title, and legal authority to collect and sue. And remember, due to the securitization, guys, this was already null and void from the very beginning. So you also have to understand, and this is why I teach in this university, how the trusts work, how to determine where to find information from the SEC, right? Because the SEC provides all that information regarding securitization. And you can also reference Edgar, right, to determine who they actually transfer their debts to, right? You can determine who they're transferring their debts to and use that against them in the case. But it's going to be case by case. You have to determine where you stand, read your agreement, and build from there. It all starts from the base, the original agreement, the letter and the notice that you received, and that's your base, right? You never want to skip steps and say, okay, well, I'm just going to go straight to filing a motion to dismiss for improper service. I mean, you got to know the ground rules. So what happens if you disagree? So the court sets a timeline, and you may be told to file a written answer or motion by a certain date, right? And the court may schedule a motion hearing, discovery deadline, or a trial date. You may serve your motion or dismiss. Raise the issue of lack of standing and ownership, right? Attach the SEC evidence or trust documents to support your claim that the account was securitized, right? And I was telling you where, guys, you can find it on the SEC exchange, right? I'll add some more links for you guys here to make it, more resourceful. So I'll attach some links below here for like security exchange and a little bit of pointers on how to search the securitization, right? Well, it's going to be different for every case, but it's going to give you guys the stepping stones that you need. So what happens after you disagree? Where the court sets a timeline, right? So we covered that. So the plaintiff must respond, and they must submit, and they may submit an affidavit or try to prove ownership. So with the affidavit, guys, you have to understand how powerful it is. Once you submit it and you don't have the proof to prove that you know what you're talking about, it's a wrap. Like, you lost. And you're getting penalized for that, for an affidavit, right? And this is why they're required to submit an affidavit, but try to prove ownership. They're never going to submit an affidavit because it's under penalty of perjury, right? It's a federal violation once that happens, right? Once that happens, it's over for them. That's why they have a debt collector ban list. So often, original creditors won't have the complete paperwork, especially in securitization cases, right? So I give you guys a sample statement here, right, that you can use whenever you guys are submitting it. If they're asking you for like a written statement, you can use this as an example, right? Now, this puts the judge on notice that you're not a passive consumer, you're invoking your legal right in defense, and that challenges their right to sue, right? And right now, they're actually attempting to win a judgment against you under presumption and assumption till it's rebutted. And now we're rebutting. We're taking our power back to rebut. So you're going to put the judge on notice, inform him like, hey, I am rebutting this and I am going to seek a defense. All right. And obviously, like any court case, man, you just want to be professional. That's pretty self-explanatory. You don't need to explain anything, guys. You get straight to the point. Don't overtalk. Remember, you're in a court of assumption and presumption. You say anything, they can assume or presume, it's over. So stick to what I'm sharing. It's very straightforward. Just to disagree. Right? You disagree. Keep it short, sweet, and move on. There's nothing really to explain because a lot of people who don't really understand what to do and say, they talk too much. So in this case, you guys are getting the pointers on literally just walking in and not having to explain yourself to these individuals, especially when you know they're in the wrong. So you're going to file your motion if it's not already done once you've gone through the initial court case, right? You're going to go through the hearing. Following that, you're going to file the motion to dismiss. Send a copy to the court and plaintiff's lawyer with a certificate of service. Track the deadlines for hearings and filings and monitor the dockets, right? Because sometimes the dockets change and you want to pay attention to those. So now that I covered all that sauce from the litigation campus, I'm going to leave it open to the chat to ask questions. Because that's a lot of new information, and we just dove deep, guys, on how to handle lawsuits. Does anyone have any questions in regards to what I went over? Was all that pretty interesting? Did you learn something? Can you guys hear me?
Yeah, we can hear you, man. It was great.
Awesome,
Definitely
awesome.
fire, man. Definitely fire.
Yeah, so
Yeah.
that's
It's
that's
it's just that it's just that the only thing is that it was an Amazon store card. I don't think it was the Chase one.
that's okay. So all we need to do is pull up the synchrony agreement.
But Synchrony probably in Delaware too. The same shit. Same stuff.
Yeah, it's all going to be in the
For
agreement at the end of the day, guys.
Delaware.
The best part about this is that you guys now know how to approach this. That's the ticket. But the secret is in reading that agreement. You guys are still going to have to read the agreement because I can read as many agreements as I need to for you guys, but it's not going to change the fact that whatever credit card you guys signed to still have to understand what's on there. So by knowing that the first step is to go into the agreement, that's gold. That is gold. Right? And so I recorded this call, so I'm going to be posting it. All right, be posting it into the campus. But I wanted to make sure I cover this. And then I'm still working on diving into the bankruptcy stuff that we discussed yesterday's call. So there's going to be more gems, guys. Tomorrow specifically, I'm going to be going over some updates on the credit repair automation business. And I'll be diving into some new processes and some new onboarding emails. I've attached them to the university to allow individuals to seamlessly onboard individuals and just make things easier. So I'm going to be diving into that tomorrow. But today I wanted to get into this topic, answer whatever question. And I'm going to try my best to also do that more of that, like where I can dive into a call related to a topic in here. And really just explain my point of view. But I appreciate you guys hopping on. I'm gonna let you guys go. If anything comes up, don't be afraid to drop it into the Q&A chat, and we'll get to work, man. You guys enjoy the rest of your evening, and I'll see you tomorrow.